Permanent Secretary, Lagos State Ministry of Justice in 1998. In 2006, he was appointed the Honorable Commissioner for Lands in Lagos State. In 2007, he was given the post of Executive Secretary and Chief Executive Officer, Lagos State Security Trust Fund, and a member Lagos State Security Council, a position he held from 2007 to 2015. Mr. Fola Atowari has delivered several seminar papers at the Nigerian Institute of Advanced Legal Studies. He's a well-known figure here, and I know he's a very favorite of the Institute. An Alpha Jurist Institute, Law Quest, the U.S. State Department Training Program for Prosecutors, and various states' Ministry of Justice. He has also delivered lectures at EFCC and ICPC training seminars, security summits, and others. Some of the papers include Prosecution Policy and the Public Interest, Structuring of Public-Private Partnerships, Law in Development, the Role of the Public Prosecutor in Advancing Human Rights, Resourcing the Police, Challenges and Prospects. Mr. Fola Atowari has also authored many books. Chief among them are The Prosecutor in Public Prosecution. He also co-authored Cross-Examination, Mastering the Trial Lawyer's Most Potent Weapon, which he co-authored with the Vice President of the Federal Republic of Nigeria, Professor Yemi Osinbajo. Ladies and gentlemen, I present to you Mr. Fola Atowari.
Thank you. I wonder who they were talking about. Yes, as usual, it's a pleasure to be here, and also a pleasure to be co-speaker with the gentleman from the United States. I shall soon be printing a card which says co-author with the Vice President. I'm in a bit of a dilemma in the sense that I don't know how far to go with this so that I don't overreach some of the next papers, but generally I'll try and run us through this very important part, cross-examination of the adversarial trial system. Indeed, there isn't any other instrument provided by the law that enables you to question your opponent's case than cross-examination. So it's very critical. And of course, it's even more difficult in a court system where, for the large part, when you ask your question, the judge probably says to you, wait, let me get you down, giving the witness time to think. And all of these things are part of the, realities of our situation. But the basic principles still apply. We run an adversarial system, which is essentially party against party, as against the inquisitorial system, where the judicial officials are deeply involved. Some of the problems here is how to keep the judge to allow, counsel to make his case through cross-examination. You find judges jumping in, let him explain, all that type of thing. So these are some of the issues I want to look at today. I forgot I was the one in charge of the thing. So I said we'll run through this quite quickly, and then probably in the question time we'll look at some of the issues that are important. So I said it's the most effective tool for giving effect to the right of a party to challenge the case of his opponent. It's consistent with the adversarial system. It's intended to produce truth or discredit falsehood and thereby ensure justice. So competing positions are scrutinized under cross-examination. Its foundation is the common law, which incorporates the tradition of live testimony in court, subject to adversarial testimony, as distinct from civil law, which condones examination in private by judicial officials. I almost said next. The gamut hinges, so basically it's impeachment. You want to impeach the other side, discredit, because a witness credibility, I say, depends on his knowledge of the facts to which he testifies. He must have knowledge, so that excludes hearsay. His disinterestedness or impartiality, so he has no motive to serve beyond the truth, even if he is related to the victim, for instance. That does not necessarily immediately confer on him a partiality, as long as it's established that he's given evidence of what he saw, heard, etc. His integrity, yes, so he's got to be someone of some measure of character, although not always the case. His consistency, very important. A witness who chops and changes has no credit. His veracity and his being bound to speak the truth by such oath as it did. By affirmation or oath. Ogun, they hold the cutlass, they swear. Those ones don't lie. But you know, in Africa, they strike, God strikes immediately. But the ones who swore on the books with your long-term judgment day, nobody knows when that will come. They are the ones that lie the most. Anyway, so the degree of credit will, of course, relate to the judge's assessment of these qualities. Fine. So, of course, cross-examination relates to examination in chief, although there are certain extensions of that. Then Section 188(2) of the Evidence Act clearly defines cross-examination as the examination of a witness by a party of ourselves that cross-examination is not just a procedural issue, it's statutory. The powers, the control, etc. are embedded in the Evidence Act. So essentially we say, why do you cross-examine? Is it just to show that you are smart, or is there a more important purpose in relation to your case? So it is, you want to produce materials or evidence which counsel cross-examining will require in his address to discredit the version of the facts presented by the other side. So the value of it will show when you are giving your final address. That under cross-examination, X, Y, Z happened. That under but if you are just cross-examining and getting the man to say, I didn't, and nobody is writing it down so you know what the important elements are, yeah, it looks good, but at the end of the day, it won't produce much value. So, yes, I have a right as an opposing party to test whether a witness produced by the other side has the knowledge of the things about which he testifies. That's my right, and nobody can curtail that right. If it is found that the witness had the means and ability to ascertain the facts or opinion, then his memory, statements, and everything so related might be scrutinized by the cross-examination for the purpose of impeachment, if possible, or affirmation of certain aspects of your case that you want affirmed. A party that feels that speaks for itself. If you don't cross-examine, the court has a discretion to say, well, you didn't cross-examine, I accept. But of course, there must be exceptions. If the story is ridiculous or doesn't damage your case, why bother? So that's another issue. So, two broad issues are usually tested by of the evidence or the extent to which it is acceptable as being free from error. Not lie, free from error. There's a very important distinction there. And then the credibility of the evidence to the extent to which it is acceptable as truthful. So the first proceeds from the premise that the witness is essentially a witness of truth, but may have forgotten or simply misinterpreted certain facts which came to his or her knowledge and therefore has not been discredited. And the second issue proceeds from the premise that the witness is lying or is not sufficiently competent to have testified on the evidence in issue. So, of course, we know that direct examination, as you've been told this morning, is almost always typically designed to tell the opponent's best story, the whole story, or wholly truthful or credible. So the challenge of the opposing lawyer is how to discredit this version. How? The ultimate goal, of course, is persuasion. That's the goal, not merely making, scoring some funny point, but to persuade the judge that, something's wrong here. There's some discredit here. Of course, one of the difficulties we have in Nigeria and what sort of constrains the value of oral testimony to some degree is the fact that we don't have juries. So this issue of opening statement, etc., does not have the same impact as it has where you have a jury. We had juries up to the 70s. Many of the cases in the all Nigeria, etc., are jury trials. But in our usual way, we began to say, how does a Yoruba man get tried by, other people? Or how will a Christian get fair hearing as if that doesn't happen in other countries? Of course it does. But in our usual way, we don't confront, we sidestep. So you are left with the judge, who's judge and jury. So the flamboyance might be good for your clients, but it doesn't really play. You don't have an audience. You just have one judge, probably depending on his mood, listening to you or not, or whatever. So these are some of the things that you have to remind yourself that, look, keep it short and, to the point. So cross-examination must either advance your theory of the case or work to dismantle the opposite side's theory. Because it's all about a theory until the judge gives his evidence. So you must have a theory that is reasonable and can be advanced through every aspect of the trial, and especially including every cross-examination of individual witnesses. So we'll look at how that works. For instance, let's say an expert who gives evidence. If you can get him to accept under cross-examination that there are other possibilities that led to the result, then you have advanced your theory without, you haven't impeached him, but you've used him to open the door for the judge to say, well, there are two possibilities, I'll go with the burden in favor of the accused. So I'm not just talking criminal. These are general principles. So as I said, you want to provide through cross evidence or materials for the final submission or address counsel. So it's an opportunity for you to gather evidence or materials for closing address that will show that your case is credible and the case of the opposing side is weak. So you put questions to the witness, which are ultimately directed at discrediting or whittling down the credibility of the witness, or to show that the witness' ability to the true state of affairs or accurately relate this information to the court, components of credibility is questionable. But when you are putting, better have substance to put. Otherwise the witness will put it back to you. One lawyer put it to his witness, or a lady, of course. I put it to you, you're not a witness of truth. And the witness said, I put it to you, you're not a lawyer of truth. So be careful what you put. Right. This is important. Experts say that cross-examination rarely discredits totally a witness testimony. I think it's only in Perry Mason and others films, TV series, where everything has been pre-scripted and you get a witness who says, yes, I did it, I lie. Yeah. The man will just look at you and say, I didn't do it. So you've got to be aware of that. And that confrontational way doesn't usually work, because we are confrontational anyway. As they say, what did they say about an American, British woman and a Nigerian? And somebody said to the American, you have only 6 months to live, from the medical report. And she goes, my God, really? Then the British person told the same thing. Oh no, I have to go and see my lawyer or something. And then they put it to the Nigerian, they say, "Nah, lie." I ain't going anywhere. So you have to understand that culture. So you want to show that your client's version of events is more credible and show that the prosecution is too weak to discharge their burden of case. That's in criminal. Putting the case, put, is to tactfully present aspect by aspect your side of the story to the opposing witnesses. So it's not just to say, you didn't see it, did you? Or you have to say things like, you were there on that morning, I was. You were there officially, I was, and so on, affirmation. But you have to have a case that's tied to your sequence of questioning. You don't just go there and start, wondering what next. No. If you are not ready, don't bother. So, in a criminal case, a party would consider its cross-examination successful if such witnesses at least accept that particular aspects of the case put to them are probable. You've described a wound, doctor, to the back of the deceased's head. You said that in your opinion, that wound was caused by a blow to the back of the head with such and such object was. But it's also possible, doctor, that such a wound could also come from a fall. Yes, in some cases, thank you. That's all. Don't go ahead. Tell us what type of stop. So you use that. But it has to tie to you can't just bring it out of the blues. You have to have some element of your case that supports that opinion. So, in this, the goal of cross-examining counsel is to put to each of his opponent's witnesses in turn so much of his own case as concerns that particular witness on which he had any part, and to get the witness to accept them as true or at least probable or plausible. So you want to change the other side's case through your cross-examination, and then you decide what type of cross-examination best suits the facts you wish to destroy or discredit and the type of witness you are faced with. As we heard earlier, it could be any kind of witness. So why would you consider cross-examining a witness? Is it just because that's the norm? Any questions? Yes, even though you have no questions. No. You have to ask, has the witness against us something that if we don't challenge will ensure their victory? Very important. Has his testimony injured our side of the case? Has he made an impression with the judge to our detriment? Where you see the judge nodding here, next. We're very excited when the judge, I was something, like just you heard, I was this, that, and the other. I was the head of something in Dallas, Texas. I was the head of whatever. Everybody's going, yeah. So if you don't discredit that position you had in Texas, you only had it for 2 weeks. Actually, well, 2 weeks. So I wouldn't call you, if I were you, I wouldn't even mention it. And then you leave him there. Don't ask him why, because he will tell you, because I was promoted to a higher level. So, careful. So, then do we have to cross-examine at all? Very important question. Is the cross-examination likely to injure or advance our case further? Because ineffective cross-examination carries several potentially damaging risks to the cross-examiner's case. It's nothing worse than being unable to break down the witness or when the judge said any better questions, as I've been told before by a judge. I was just going on that day. The judge said, listen, Mr. Warrior, any better questions? If you don't have, sit down. Oof. That was it. So through cross to reinforce the testimony. Because the court will say, even under cross-examination, even under vigorous cross-examination, the witness maintained that's not, you don't want that. You don't want the judge to turn against you because you're just being a bully or just being insistent, asking the same question over and over again. The judge will say, what. I don't, like in one case happily I was not on the, I was on the right side this time. And the counsel kept going, and then after a while looked at the judge and said, my lord, you are not writing, and the judge, who had sat almost backing the court, said, I don't write rubbish. So, careful. Testimony in chief. Significantly, the scope and effectiveness of cross-examination, if decided upon, should be determined, as I've said, by the amount of damage and the potential for favorable evidence being revealed to the judge so that you reverse that. So a judge, what does a judge look at? Demeanor, personality, reaction to questions from counsel. All of these go to leave a cumulative impression on any judge. I cited a very old case. My philosophy is that it's not the number of cases you put. Half the judge don't need to be assured. And I don't go, but they don't know. Find the earliest time that the Nigerian courts settled on the principle, and then the latest where they. Thank you very much. Okay, makes the judges' work easier too. Now, 6 main purposes, I said. As I said, veracity, you want to test his legal competence. Is he mentally, whatever, is he a child, an expert? These are all, even though they are matters of fact. Then, so I said either to testify as an ordinary witness or to render an opinion as an expert, to weaken, overcome, qualify, explain, qualify. Very important. One opinion can be qualified. One statement can be qualified. When you said this, you actually meant this. Yes. Rather than just leaving it. So, like I said, the object is not to get the man to say, I told a lie. That doesn't work. We don't admit we lie, even when it's staring us in the face. So don't bother. So you were lying once, I wasn't lying, but that's how I saw it at that time. So you want to qualify his evidence. Then credibility, knowledge, recollection, very important, by exposing inaccuracies in the direct testimony. But not all inaccuracies will lead to discredit. Just the inaccuracies in the normal recall of an event. Then inconsistent practice, very important. We'll look at that briefly. Then to contradict, destroy, or discredit the other witnesses. So without warning him, you can get him to say something that was different from what witnesses of his own side said. You've already, and then to establish your case through his witnesses. So you can ask certain questions of his witnesses that support your case. Right. So, cross-examination, what are you looking at? You are looking at, in relation to the subject, his interest. Does he have an interest? His motives, his inclinations and his prejudices, his means of obtaining a correct and certain knowledge of the facts to which he testifies. How did he, what gives him the basis for speaking? You have to, examine that. The manner in which he has used those means, his power of discerning the facts in the first place. So that's like for instance, identification. I saw so. Then, careful though, how you interrogate identification matters. Otherwise, you might just help him support the case. So if you said, for instance, a man who is identified after a robbery in the dark, no lights that night, has happened in one of my cases. And the defense counsel said, it was dark that night, as usual. Yes, sir. As usual, never had taken off the light. Yes. And yet you saw this man. For how many seconds? Maybe 10 minutes, but I saw it. Okay. In the dark, yes. At 2 a.m. in the morning, yes. Very good. He should have stopped there. But he said, how did you do that? The man said, after many years of adjusting lightless living, I have become like a cat in the dark. And I could see him. So, careful. So if you are going to interrogate, how did you know where to stop? Right. Then consistency or lack thereof, and so on. Right. Now, you have to, there's a scope and a limit, like everything in cross-examination. Some people say the sky is the limit. No, can't be. So there are exclusionary rules in the Evidence Act, and some level of discretion in on the hands of the judge to determine certain things. But it's the Evidence Act. So you've got rule against hearsay, rule on character evidence, limited, unless they made character an issue. The rule against indecent and scandalous questions. Indecent and scandalous. So, in a rape case, that I say, my case is that the woman is a serial, whatever it is, serial. So I want to ask her, you have multiple sexual partners. Is that indecent or scandalous? So it's a foundational. If you just do it without purpose, then it might be. But if it's part of your case, and you have to argue that before the judge, that our case is that this woman sleeps with everybody in the neighborhood. So, judge said, no, that's indecent. No, it's my case. So there's, it's always a discretionary. The key, justify your question with reference to the theory of your case. So don't just be, at large. You have to, be focused. So, then rule requiring caution in the treatment of the evidence of accomplices and other witnesses who may have a conflict. Generally, cross-examination is subject to the rule of admissibility of evidence. Generally. Then, as I said, Evidence Act is the guide. It allows flexibility. It permits counsel to question the witness on any subject relevant to the dispute. And the matters on which the witness was questioned on direct examination. Remember, we said direct examination is generally designed to tell the best story of the other side. So you are enabled to go outside it if you have certain facts that he have omitted and put it to him. So if he said, I'm a man of impeccable character, that's why I was made the MD of this company. And when the other side came in, that's when things started to go bad. We never had a problem until the accused or the other party came in. But you know different. You know that he'd been sacked from 3 of his previous appointments. So you put that to him. It wasn't indirect, but it's relevant to his credibility. So, admissibility remains, as we know, to relevant, but note that while facts may not be immediately relevant for the material facts in issue, they may be relevant for the purpose of cross-examination in terms of accuracy, veracity, credibility, and questions may be asked of them, such as who he is and his position in life, etc. So, as said in Otampo and Obinabo, the court said the scope of matters over which a witness may be cross-examined is almost infinite, but is qualified by the fact that the outside limits of cross-examination fall within the discretion of the trial judge. Very important in determining that this right is not absolute. 200 to 210, I'm sure you've all looked at that. And we said evidence procured from cross can only be admitted if it is relevant to the live issue before the court. Okay. Now, plan. Life is about planning. Life is about planning. Maybe because we didn't plan to have Nigeria. Planning is a problem. After all, we didn't sit down and say, let's have the country. What do we call it? Nigeria. We just found ourselves. So we have to accept that that's how it is generally. Planning is a challenge. If you don't plan, you're not likely to get it done. But you can correct. Remember, that's also a plan. You start a journey and say, we forgot, and then adjust. So, what are your objectives? What do you want to achieve? Very important. You must be able to ask, why do I want to cross-examine? what is my case is at the heart of every trial. That was the late Senator Adesoya's mantra when we meet for anything, talk about this, and then after a while say, oh, gentlemen, 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 enough. What is your case? Not what is the evidence, what is the case? That such and such a thing happened, such and such, for such reasons, and this was the result. That's your case. So you now design and plan around your case. So, then you plan, as I said, to secure the purpose. So generally, and this is not a strict rule, but you must have a plan before the witness even gives evidence in chief, because you must have an idea of what he's going to say. Although in criminal, they can spring a surprise on you. They are not obliged as defense to make disclosure. So I can get a witness just around the corner. When he comes, I just want you to say X, Y, Z and go. But you still, then you should have a fair idea of where the cross-examination will end up and why you want to elicit particular person. So the objective of cross-examination is one that must be clearly defined. And when that goal is reached, counsel should terminate the exercise and resume his seat. That's why it's good to know what you want to achieve so you don't overreach. Don't ask more questions than are necessary. So, what you want to achieve is that you want to establish that the witness is lying on one or more material points. This is important, that saying to a witness who said the accused was wearing blue shoes when the evidence shows that he was wearing red shoes, and you get him to say, well, yeah, okay, I think they were, maybe now that I think about it, they were red. It's not a material point. Because if you say, why did you say that they were red when they were blue? I say, I don't generally look at shoes. That face, I can't forget. So, it's not material. If you had said, are you sure it was fair or dark-skinned? Then you are beginning to look at issues of identity. Now, to show that the witness is prejudiced by whatever, whether it's his religious leanings, whether it's his political leanings, whether it's his cultural leanings, or whether he has deep issues with the other party that go beyond the facts of the case. To show that the testimony is improbable or implausible, couldn't have happened in the way that you described. The man jumped from 10 stories. I saw him. He jumped 10 stories, hit the ground, bounced again, and ran off. Are you sure it's the same man you're talking about? 10 stories? Yes. So that's also an issue. And then you stop there and use it for address. Now, you don't need to say to the witness, but that's implausible now. No. Just then, where it's to qualify as mentioned, to prejudice the opponent's case, to force the witness to admit or deny certain facts which are in your favor, to weaken the testimony of the witness by showing that the evidence is questionable because it is based on false assumptions. To show that an expert, so if you can get the man to say, well, I thought, then you've got him, I thought. To show that an expert is not qualified to render an opinion because he or she lacks the necessary training. The opinion of an expert is not supported by accepted science or method. To do all the research possible into the field on which the expert is coming to give evidence. We must not presume. So I can challenge even his status, whether you are truly an expert. And I can challenge, important, the method. If you give evidence of your findings, then it's open to me, but careful, to question the method. Is it the accepted method you used? Because there are accepted methods. If you went outside that, there's an issue of credit. So very important that you research the field. If it's a forensic, what do you call it? What do they do in EFCC now? It's forensic accounting. All of these things are important. Now we know that when we use the word forensic, what do we mean? Can anybody tell me? Forensic. If you say forensic accountant, how is that different from a regular accountant? Can anybody tell me? No? Forensic pathologist. When you use the word forensic, you are talking about scientific activity designed to resolve legal questions important to the state. So if you say you're an accountant, and I can get you to admit that you really don't have specific training in this field, I might weaken your credit. Although the Supreme Court has said experience might take the place of specific skills or knowledge. So it's important. Now, yeah, so I'll go on because I think I better start moving quickly. Okay, then contrary statement previously, very important. And then you want to create the impression that the cross-examination was successful. Strengthen your case from examination, you said that. You want to show that the witness was coached. And I always tell people, if you are preparing your witness, please do not ask him to memorize a statement, because he'll get it out of. Just say to him, tell it as you recall it, and keep telling it as you recall it. Don't read the statement, because he'll jump one paragraph and say, wait, I forgot. And then, you now say, you don't seem to be, very clear about the sequence of events. I say, well, it's what my lawyer told me to say. So, careful. You want to supplement the witness direct testimony. That means to say you want to add to those parts he omitted. Yes, you did this, but remember that there was also this, and you must not be confrontational. So it's almost a conversation. So we say, we're here just, everybody say that. We're Christians now, we're Muslims now, we're religious, we're Nigerians. We tell the truth, yes. Yes. You know how, if you truly fear God, truth is important. Yes. Then you move on. So you have to play on the belief system that we have. So, to establish an evidentiary foundation to admit a document, very important, foundation. So you might want to put through him a report, right, from his own institute that contradicts his own testimony. So you put questions to him, you are part of this, you did this, if you see this report, which you are a part, then you put it in. Then you now point to him the contradiction between what he said today and what is in the report. And then to enhance or destroy credibility of other witnesses. Okay, so preparation, etc. I think we've said this. Intuition and careful listening skills. You can't really learn cross-examination. You can learn the principle, but you can't learn when the man says this is what you say. No. So remember what is your case and what is your objective. So good intuition. Sometimes it's just a feeling. Follow him there. The way he's looking when he answers that question, I think I'm going to follow that area. And please listen like a bat in the night that hears anything move, because he may just say something and you say, aha. Okay, so they say these are not my words, they are the words of experts. Experience is important, yes. People have it, some people are good at it. Preparation, most important. Organization. Approach to your cross-examination. Form and flexibility, of course. Then you must know all the facts of the case. Otherwise, what is the background on which you are cross-examining anybody? And you cannot hope to catch a witness straying from the truth or embellishing an actual recollection without a complete mastery of the facts. You must know the facts of the case. Okay. So we heard part of this earlier. What type of witness? Then do you need to? Then what order do you ask your question? What question should I not ask him? What do I want to achieve in cross-examining this witness? What words should I choose to frame my question? What method? So some people write out every question in advance. Some just put down the subject matter they want to interrogate and form the questions as they go along. Since you can't anticipate all the answers, keep an open mind so as to assimilate and maximize the use. Never ask a question to which you do not. Very dangerous. That's like going to fish in a lake. There are sharks and there are ordinary fish, and you don't know which one is going to. So be careful. Then subjects about which the witness cannot avoid giving testimonies, to sort of lull the witness into a sense that you are sort of arguing. You went to school, I did. You're a degree holder, yes. You rose very far in your profession, I did. In fact, you're one of the most celebrated members of the day. Look, man. So you are just dragging in. In fact, you are considered the best in the field. Yes, yes, I am. Yes, yes. How many awards have you got, sir? I understand there are many. Yeah, well, other awards from the UN, from many now slip some. So begin with areas in which the cross-examiner and the witness are in agreement. And then at a stage you've got control because you've created a relationship, if you like. So don't fish, but it's not absolute. You can take the risk of asking questions if you have an expectation that it will come out in a particular way. You may have to cross-examine a witness on areas he had no prior notice of. Listen attentively, write down those areas worthy of note, put questions previously asked of other witnesses to him. His answers might contradict theirs. Put questions to him on settled facts. Master the rules of evidence. Then we talked about probabilities or plausibilities. Probability is never detected during false testimony. Belief by the court in a witness testimony must be in consonance with the general drift of the evidence and the probabilities, which on the totality of evidence it is natural to expect. I-ban B. Belief is subjective, but the judge will subject the evidence to an objective test of probability. Use experience and logic to think through what probably happened, etc., etc. This is all about probability or plausibility. Techniques. Control. You must have control. And the way leading questions. Leading. As you know, leading questions are generally not allowed, but the evidence law is specific that leading questions may be asked in cross-examination because it's an adversarial system. So you want to ask questions which you get yes and no answers mainly, not explanations. This is what happened on the night of this, yes. And you went to the bank, yes. And you withdrew some money, yes. After withdrawing the money, you got into the car with your wife, yes. She slapped you across the face and asked you why you got so little, yes. You had to return to the bank to get some more, yes. To avoid being slapped a second time, yes. Etc., etc. Don't start saying, but why did you allow your wife to slap you? So, don't allow the witness. It will only reinforce the value of his evidence, or to fill in gaps or repair possible damage that occurred in his evidence in chief. So be careful what you put to him. What you put, you know what a leading question is? A question that contains within it the answer. So don't become argumentative, because you lose the esteem of the judge and the witness will feel free to take liberties. He'll look at you and say, this one is a lawyer. I mean, I'm today. So, and you know, everybody believes they are lawyers, somehow. Okay, so an argument brings the witness and the cross-examiner to the same level. So if the witness is getting unruly, don't you try to refer it to the judge. My lord, I plead that you get the witness to. But if you start saying, as we do sometimes, my friend, you are in a court of law. You must behave yourself. You've lost it now. Man will say, you are the one annoying me. You are the one annoying. Judge will say, you see? So, leading questions, potent instrument of control. Critical. I always get this question. A judge must not force on cross-examining counsel answers or evidence he does not want. Let him explain what many judges say. For me, it's a matter of fair hearing. We see it all the time. You only want yes or no. And then the witness says, but, and then you say, I'm done with you on that. And then the judge says, let him explain. That defeats the purpose of the adversarial system. If I have time, anyway, in my book, I'm not trying to market the book, but let me just read to you what I thought, because it's a question I always get, and it appears that many judges don't get the fact that although you are allowed to, quote and unquote, step into the arena sometimes, you are not to prejudice them. This is a time issue. Oh, okay, fine, all right. So, I'm being told that I have time, so I'm going to take advantage of that then. Excuse my, bear with me a little. Okay, page 40. So I'll just read it because I think it is important. Because the thing is that when the judge does that, then you have to be able to make your argument. For me, it's even a matter that is appealing. Now, let me read what I said. I said, or we said, sorry, me and the vice president. I must not, sorry, the acting president, sorry. So me and the acting president said that in our view, the attitude of such judges is wrong. Not only because it affects counsel's ability to control the cross-examination, but more fundamentally because it fails to appreciate the adversarial nature of proceedings under our trial system and fails to take into cognizance the underlying jurisprudence of the examination in chief, cross-examination, and re-examination sequence in trials. It is our further view that giving a witness an opportunity to explain away a fact which he has admitted under cross-examination, or an inconsistency with earlier testimony damaging to his case, is a denial of fair hearing to the party that has obtained the admission or fact or exposed the inconsistency, because it defeats the purpose of his cross-examination and prejudices his case. So for me, when the judge insists, go to the fair hearing argument, refer to the fact that it is the evidence law itself that sets out the sequence of questions, not a practice issue. It's a fundamental statutory fair hearing issue. And that if the man wants the witness to explain, there's re-examination, which you watch very carefully. So we must be very clear about what our rights are as counsel under an adversarial system. That is not the role of the judge to prejudice my case by insisting, because what it's doing is forcing evidence on you that you didn't want. So that's very important. Now, so we go further. So we said leading questions 197. Asking only leading questions is perhaps the most enduring rule. They are effective because they essentially allow the cross-examiner to testify and the witness to endorse. So you are testifying by your leading question. You are putting the case to the other side. And once they say yes, that's evidence. So that's very important. Control. You don't want to lose control of your witness. Now, so you want yes or no as much as possible. If an explanation, so tight reins, yes or no, don't allow the witness to make a speech, otherwise it will embroider his testimony. Avoid questions such as why or will you explain. Leave that. They are called the enemy words because it opens the door to the witness. So ask a quick, let's say a witness has contradicted himself. He has agreed that yes, the statement I made today, the evidence I gave today is different from. Then you say why? The man can give you any number of reasons, and the judge is now open to the judge to say, while at first glance this, but he gave a reasonable explanation. I think I will, so because experts call them the enemy words because they are an invitation to the witness to take control. When that happens, etc., yes. And if you want him to explain, make sure it is an area far away from the central issue upon which the witness needs to be cross-examined or impeached. So you may want to give the judge the impression that you are, what's that word? And so you want to show that you're not nothing against it. So, yes, and so just explain why that happened. But make sure it's not fundamental. So that's for impression. Now, that's why we've done that now. You want control and the judge is intervening. So, et cetera, and I think it's appealable. Don't use adjectives, right? Because that is an argument. You couldn't see, could you? I could. You were standing 100 feet away. Yes, it's better. In your address, you say, there's no way you could have seen it from 100 feet as clearly as this. But if you say you couldn't, you say I could. I have good eyesight. In fact, I had the best eyesight in school. Everybody used binoculars. I didn't need to. That's explanation. So, it is safer to consider the facts garnered from prior discovery and then turn each into a fact. So what you are doing, you are giving evidence. That's what you are doing. You were standing across the street behind the truck when the accident occurred. Yes, evidence is better than you couldn't see now because you were standing behind. I was standing behind, but actually I was leaning this way. Because the easiest thing to do, we've all done it even as kids when we're interrogated by our parents about who broke the plate. You are smart. So why did you break the plate? I didn't mean to. It was because. Then I can start saying, I've always had shaking hands and all of that, and I told mommy and they didn't take me to. All right. Just go. So brevity, please. Questions too long and clumsy and so on. The judge will. If you have just a few points you want, hurry it up, get the points, sit down. Some people think that they can hide the poison in many questions, but sometimes you lose the interest of the judge. So, the danger of disregarding brevity is that it permits the witness to simply retell a story as already related, and this merely serves to strengthen its effect. If you are compelled to conduct an extensive cross-examination because of discrepancies or because the witness has damaged your case, then you want to lead the witness to an acceptance of discrepancies or question his testimony as being biased, etc. When a counsel has garnered some strong and useful testimony from a witness, he must avoid pursuing it further for the purpose of emphasis. You want to look back at your clients and say, you see how I'm doing? So tell us why you did that. The man will do like this. You see the reason it goes back 20 years. I have to go back into my history. So, if you do that, the witness will know. Why is he focusing on this matter? I made a mistake. I will change it. Stop. Do not ask unimportant questions. A question that does not advance your case may judge. Remember, the business judge is very difficult, especially if you are writing longhand. Just keep it simple so I can, write it down. Hiding a vital question in the midst of a forest of unimportant ones may take the witness by surprise, but the value of the admission might be lost on the judge, who may by this time have become bored or confused. It may still have its value since you can point out the admission at address stage, but you might have sacrificed some of the value, some of the impact. Quit your cross-examination when the witness is destroying the case or embarrassing counsel. So it's not an ego fight. It's a case fight. So, at that stage, concede when you come up against a witness who is too smart, who strikes back hard, squeezing into his answers injurious facts. You say, but when you did that, you knew that the man... Go and ask the neighborhood. The man is a useless man. So, be careful. So not every witness must be subjected to cross. I believe that's it for now. So I'll take, like I said, you can't cover the whole cross-examination. It's very dynamic, very broad, but these are the basic things. Know your case, know your objectives, don't ask too many questions, brevity, don't go outside yes or no answer. Those are the main issues. So if there are any questions. Yes, sir. Okay. 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 Yes. Yes. For who? No, it's not your question. No, I said yes. No, that's not what, I don't know where that rule came from. That's not what the law says. You must remember the law. The law says you can question matters that arose in cross-examination. I don't know where this, and I don't know of any case that says ambiguity only. So let's be clear. Like I said, it's a statutory matter. It's adversarial. Adversarial cases are cases structured on opportunity. I have my opportunity to present my case. It is not your business, right? What, and I don't say this, I'm not having a, we are saying, at the time of cross-examination, it is my opportunity to discredit law and to elicit from you certain facts that support my case. Now, if I'm not offending any of the admissibility, relevance, or hearsay rules, you can't, it's not, I want yes, that's what I want. You say you are a doctor, yes, but not a medical doctor. No. You are actually a PhD in sociology, yes. But you walk around calling yourself a doctor, yes. That's because you know. I don't want to know. So you can't get up and say, objection, let him explain. That's not understood by the law. So I'm saying that because if the law had not declared the sequence of the examination, then we could say, well, it's open to. It's very clear. It's an adversarial system. He is each side challenging the other's case. Direct evidence, the only time I can disturb you on direct is if you are going to hearsay. That's about the only time. That's it. When, or you're asking leading questions. Those are the two leading questions. I cannot put my witness in the box and say, when you got there, the door was locked. I will object completely. When you got there, what happened? I tried the door, it was locked. So what did you do next as you think of? When you met it up, you broke it, didn't you? That is leading. For cross-examination, I don't have that restriction. That's why the law particularly says leading questions may be asked in cross because it recognizes your own opportunity now. So I can now put evidence in your mouth. When you got there and you saw the door locked, you broke it, didn't you? Yes. You did not wait for the authorities to come and open it. No, because I am not interested in the court. You acted in this manner. Yes. But you consider yourself above the law. Well, no, now, that is my prerogative. It's not for the judge to say, let him, I don't want him to explain. I just want to establish the fact that they acted inappropriately. Now, under read, you can then say, it's not your normal behavior, is it? To break law. No. Why did you break it in this case? Now, yeah, hold on. You see, what you are doing is, you are putting yourself in both camps at the same time. It's not my business whether you want to object. That's the question I want to ask. It's left to the court to make a ruling. It's adversarial. As your adversary, I want to challenge what is said on cross. Now, the judge may say, careful, Mr. Adewale, you don't want to be open to case. But remember that the Evidence Act says that if in read you raise new questions, that can also be subjected to cross-examination. Isn't it? And then, that's the thing. That's the thing of it, it's adversarial. Now, and that thing is for the judge. But when you say the rule of ambiguity, if we define it, if you say matters that were not clarified in cross, that
the door is the issue, then put it to your witness. You broke the door, no issue. So you are direct to the examiner, but also anticipate what's coming from the door. So lay out your I did wrong in this area. Deny trust the ability to bring it up. That's how I would approach it. Any other? Yes. There's a question where lawyers will argue. Yeah. Yes. Which one? Yeah. Yes, yes. Yes, yes. It's all a matter of and judging. Yes, but I think the judge will say it's less easy to explain. Under cross. Yes, under cross. Yeah. Because they also feel that there is a need to get to yes. And not just. But that is good if you think it's tutorial. If it's the shout there and they do it see that as very. So don't stop my case. As long as I have not gone outside of the exclusionary area. Leave me alone now. Because when you say, look, the same act itself says that I can ask leading questions. So I know why I want to ask leading questions. You took the car on that night, yes. And you used it and emptied the tank, yes. And then you parked it back to the near empty tank, yes. That's all I want. Then, the man there is because so I say that to your counsel and all should have said it. So it's up to the other side to repair damage in ring. It's not, you can't use my time to fix your case. That's the point I'm making. We are adversaries and the judge must be careful to the extent to which steps in their ring. And the law says the judge may ask any question at any point in time. We know. But saying, let him explain, you are not the one asking the question. My question, leave me with my question. If I finish with him, and then the judge, in some perverse way, says, now that he's finished, now is my point. Because I want to get to the detail. And I say that, strictly speaking, that offends the common law principles of law. Strictly speaking. The judge should not ask questions that prejudice the other side. Should ask questions that help him clarify. Understand exactly what's happening. It's not necessary, it's a context. Each side is put on. I agree that may be, but if we adopt that view, then there's no point having a context. should stop beating your wife is not indecent. Yes, the judge has, and that's what I said. The judge, that is different from let's explain. That's different. Stopping indecent, stop. That's a stop. Don't ask that question, it's inappropriate. That's different. Rephrase it. It's different from I want a particular answer under my opportunity to make my case in an adversarial system. I say, I object. It's a factual question. Yes or no? If you say no, I can establish the fact that you do and further discredit you. If you put it this way, then I have no leeway. I must have leeway to challenge your case and make my case. Otherwise, what's the principle? What's the purpose? So if you get up and say, my Lord, that question is unfair, you have to justify it. If I say, in a rape case, if I say, I'm now for the defendant, our case is that this girl is now, in normal circumstances, I call that a case. But in some context of this case, this is the factual. So you explain to me, you can explain under your examination that either that reputation is undeserved, or that yes, I'm doing but in this particular case, because I never liked this particular guy. My useless is irrelevant relating to this guy. So, I mean, look, I'm sure we can get it, it's not mathematics. But I'm saying that judging from the principles of adversarial trial under the common law and the fact that the evidence more specifically provides periods of questioning, then you have to take it from that context. And the power of the judge to intervene is so unlimited. You can't intervene to my prejudice. He can say, and certain questions the judge will report. If recorded, I can use an argument and say that judge's question was unnecessary, was inappropriate, and the judge is not the absolute the law. So these are just some of the things. But we will go on with this forever. That's my question. Okay, thank you. Anyone done?
Thank you. It's been a pleasure.
Thank you very much.
Another round of applause. Another round of applause. I am sure all of you enjoyed that particular lecture as you have been enjoying the other papers of today. That is what you will have. Come Thursday, the ending of this workshop, you will have opportunity to ask your question because there's going to be a panel discussion. All the discussants will be there and you'll be able to engage directly and take them up on any issue they come up with. We're able to get some questions in now because indeed we had more time during this particular lecture. But indeed, on the 11th of May, Thursday at the end, we're going to have a panel discussion where you will have opportunity to grill him further on any issue that he raised during his presentation. Okay, it may interest you to know that this event is being streamed live, and if you are here, you're on Twitter, you're on Instagram, you're on Facebook, you can actually give out the information that is being streamed on www so that your friends can see you, or people that were not able to make it today, people that are in court or held up somewhere else, they can actually join us online and watch everything we are having here today on www.cwag.org. Thank you very much. And to take us on the last presentation for today, because I mentioned earlier that we're going to have case study tomorrow. In the morning, we're going to have practical examination, practical exercise on direct examination. Practical, because today we're going to have all the lectures and all that, but tomorrow morning at 9 o'clock, we're going to have practical examination. And to help us in that, there is a case study already provided in your workbook. If you look at after page 49, after the briefing notes, you will see the case study. The case of People and Castro, not our Emeka, but case of People and Castro. And I can tell you that that Castro there is in America, not in Nigeria, so it's not our Emeka. So we will have Bill to give us more on that as he takes the fourth interactive lecture, which is on theory of the case of analysis of People against Castro. This is to prepare us for tomorrow. And to take us on that is Bill Weinhoff. And before he comes up, I will just give a brief bio on him. Mr. William Weinhoff has been the supervising deputy attorney for the Land and Transportation Division of the Department of Attorney General, State of Hawaii. The division represents both Hawaii Department of Land and Natural Resources and the Hawaii Department of Transportation, which is responsible for Hawaii airports, harbors, and highways. Mr. Weinhoff graduated from Stanford University Law School in 1979. He worked in private practice in Hawaii until 2001. His private practice focused on complex real estate and commercial litigation. He joined the Department of Attorney General in 2001, and from 2001 to 2013, he has represented the Department of Land and Natural Resources. In addition, he handled complex dispute resolution matters for all state agencies and departments, especially resource protection, environmental and constitutional litigation in state, federal, and administrative forums. Ladies and gentlemen, I present Mr. Weinhoff.
Thank you, ladies and gentlemen. It's really an honor to be here. I really appreciate the privilege of coming and speaking to you folks. And I'm also really honored to be on the stage with the folks that I've had the opportunity to talk to a little bit and to hear them share some of their stories off the record with me about the experiences and important things that they've done in the state of Nigeria, the country of Nigeria. So again, I'd like to start off by saying thank you very much. I really appreciate the opportunity to be here. It's a real honor and pleasure to be talking to you this afternoon. So far what we've been talking about, we've talked about more the broad picture of oral advocacy, and the purpose, of course, of this seminar is to steep ourselves a little bit and actually go into trial. Some of the folks that we've had here have had many trials. I know Scott has said does many trials each year. I've had the privilege and opportunity of having 10 or 12 jury trials, which is actually a lot in the United States for civil work. I don't do a lot of criminal work, but each of us has the opportunity to go there. The way that we're presenting this particular seminar, and now I'm going to start focusing on, as the mention was already made, of the materials that you're going to be provided. And what we're focusing on, and some of the next couple days will be more of a practical hands-on. Each of us here will have the opportunity to do a direct examination, to do a cross-examination, and perhaps to do a closing argument or a statement, as we've said. So the facts that we're going to be focusing on here is a murder case in which Mr. Juan Castro, is accused of murdering his girlfriend Maria Flores. So what I'm going to do is I'm going to talk a little bit about the facts of those cases. Each of you has the material. You'll have the opportunity to read it over the evening and to prepare your own work for tomorrow. So I'm going to go over the facts of the case, and then we're going to talk about the theory and theme of a case. Why do you have a theory? What is a theory? What is a theme? And my colleague here has already mentioned theory and theme. What you want to have is you want to have a unifying principle. So how do you get there? Well, the theory and theme of a case, of course, depends critically on its facts. And what you want to do is you find out if you're a defendant or you're the state, what are the good facts for your case, but also what are the bad facts for your case. You can't overlook the facts that are problematic. If you're in our country, many times you'd have a jury, not always though, and here you have a judge. What are the weaknesses of your case? You don't want to have the judge hear the weaknesses of your case from the other side. You need to identify them yourself, and you need to take them on, and you need to talk about them, because there's an explanation for your weaknesses, and if you give the explanation, then that it comes out a lot better than all of a sudden you've run away with it on your case, and all of a sudden your opponent comes up and says, well, what about this? What about that? We haven't heard about that yet, have we, Your Honor? No, you want to take those out and you want to deal with them. So anyway, the basic facts of this case, as you'll have the opportunity to read them, is it is in fact a murder case. the way it's presented is Officer Salazar receives a call at 8:34 p.m. 8:34, I wouldn't usually go into the exact times, but that's a really important time, as you're going to see when you look at this case. At 8:34, Officer Salazar receives a call indicating that the dispatcher tells him that she has received a call saying that there's potentially a burglary in process. Officer Salazar drives over to the house. He parks in front of the house. As he gets out, he observes that the lights are on in the house. There's a red car parked in the driveway. Draws his gun, goes into the house, and inside the house he sees, he hears Juan Castro. Juan Castro calls from the back room, "I'm here, come in." Officer Salazar goes into the back room and he sees a body on the bed. Juan Castro standing over the body. Juan Castro is soaked in blood. The victim is lying on the bed, covered with a black coat. And so the story that Juan Castro says is, I just got home from my job. I got in, my girlfriend, I saw her lying on the bed here. I tried to resuscitate her, and when I was unable to do that, then I called the dispatch. So that's the basic layout of the facts. Then we see that Detective Lopez now comes onto the scene. Detective Lopez talks to Juan Castro. Juan Castro tells him again the story that he came in and his girlfriend is already dead, unsuccessful in resuscitating her, and then he calls the police. And we'll loop back to that timetable, but Juan Castro says this is why 8:34 was really important. Juan Castro says that he has an alibi. He wasn't there. He was at his place of business until around 8:30. And so he got in. That's consistent with his story that he saw her, he had a minute or two, and then he called in. When Officer Salazar and Detective Lopez come in, they see that there has been a struggle. Items are over to an ashtray that has apparently been hurled at a window, cracking the window and falling onto the ground. One of the things that usually when these seminars are put on, people, the preparers of the facts try to have something good for each side, right? So it's not, well, this is a slam dunk, open and shut case for the defense or the prosecution. One of the very important and interesting facts for the defense in this case is that ultimately Detective Lopez and criminologist Delgado determined that there is an unidentified fingerprint on this ashtray, obviously giving rise to the notion that there was in fact a third party in the room. So anyway, so Detective Lopez, after observing the scene, after talking to Juan Castro, then he goes out to talk to the neighbors to hear if the neighbors have heard anything or seen anything that might be helpful. So he goes over to the person on the right. The person on the right, it turns out that there's I think a young boy, I forget his name, Carlitos, or I forget his age, Carlitos Rodriguez and Paul Rodriguez, his father, live in this house. And what the story that they tell, Paul Rodriguez himself says, well, I didn't really see anything. I was watching TV. I didn't see anything or hear anything. And then so Officer Salazar talks to the young boy, and the young boy has a very interesting story and potentially an important story, because what he says is he was out in the backyard before, after he'd eaten dinner, he goes out in the backyard before 8 o'clock, maybe 6:30, 7 o'clock. And when he's out in the backyard, he says to Detective Lopez, I saw my neighbor's car in the back alley. Now, so remember, Officer Salazar drove up on the street from the front of the house. At that time, he saw the car in the driveway at 8:30, 8:35, and he went in the house from the front. Well, it turns out there's also an alley behind the houses there. And so when the young boy tells Detective Lopez, I saw my neighbor's car, and the boy says, I really like that car. It's a red car, really a fun color. And so Detective Lopez says, "How did you see the car? You were in the backyard." And the boy says, "It was parked in the alley, in the back." And the boy, remember now, the timeline is, the boy is saying it's 6:30 at 7, okay? So then Detective Lopez goes back and talks to the dad, and the dad says, "Well, if my son said it, then it must be true," etc., etc. So then Detective Lopez goes over and talks to the person on the other side. Person on the other side turns out to be an 85-year-old woman who is actually very friendly to the accused, ultimately the accused, Juan Castro. Tells Officer Detective Lopez that she doesn't really like the victim, Maria Flores. What this neighbor has to say, though, substantively is she heard and saw Mr. Castro coming home at 8:30, and she knew the time. I think it was because she was watching TV or something. And how did she know it was him? Well, who else would it be? He friendly waved to her. Couldn't have been anybody else. And so, you know, there'll be one of the areas that might be ripe for cross-examination. You don't see that well, and all the techniques that you'll be thinking about yourself. But anyway, that's her story. She sees Juan Castro coming home at 8:30. He did not seem agitated. He seemed friendly. She didn't. And another important point is around 8:15, before Juan Castro got home, she had heard a disturbance. She heard some sounds over from the house. So again, you know, suggestive, of course, to the defense that something happened before Juan Castro got home. She didn't really make a notice of that. She thought maybe it was a TV or something. So, Detective Lopez, so anyway, there's also the criminologists. Well, okay, I'm going to skip back. Detective Lopez, now that he is alerted to the fact that there's this alley in the back and that important activity may have gone on in the alley, now he goes back into the alley. He observes that the alley is gravel surface. It's dead end on this side and goes out this way. So he walks down the alley in the direction where a car could go out, and he sees a trash can. Opens the trash can, and inside he observes a blood-stained towel. Inside the blood-stained towel is a knife. And I guess, I'm sorry, by this time he had observed that the method of death appears to be that the victim was stabbed multiple times. She had also contused. She had been hit, but she had been stabbed. And so, of course, you know, blood-stained towel wrapping the knife is very important. He takes it into custody, walks in, talks to the criminologist, and turns it over to the criminologist for that person to be, for the blood to be examined, etc., etc. He also observes, Detective Lopez observes, that the towel in which the knife is wrapped is a match for a towel, another towel that's in the bedroom. They're both green towels, so it appears that this blood-soaked towel in the trash can was taken from the bathroom. He also observes one more piece of evidence. You'll see in the house, the knife itself does not have any visible blood stains on it, but it appears that there are actually blood stains, or what look like blood stains, in the sink of the bathroom, indicating that perhaps the knife had been washed off. So criminologist Delgado is the third police officer that's involved. He goes out, he takes possession of Juan Castro's blood-soaked clothes. He observes that there's a piece of gravel in the sole of Juan Castro's shoe. He takes a look at that. He goes out into the alley himself and takes a sample of the gravel to compare whether they're the same or not. So that's basically the story with respect to what happened on that particular night. So the next day, Detective Lopez continues to investigate the matter. He talks to another character is now introduced, a person named Mr. Golan. Mr. Golan is a friend of the decedent, a friend of Maria Flores, and what he tells the detective is that Maria had called him the day before or a couple days before and said, Juan Castro is very dangerous jealous because he thinks that you and I are having some sort of an affair. I'm sorry. It was actually Mr. Castro had come over and told that story to Mr. Golan. I believe that you're having an affair with my girlfriend. It's really inappropriate. Don't ever contact her again. And if you do, then you're going to be sorry. So Mr. Golan tells that to the decedent. The decedent, according to Mr. Golan, says, I'm going to talk to Juan about it, and I'll straighten it out. And Mr. Golan says, I don't think that's a good idea. There could be trouble from that. And in fact, Mr. Golan is convinced that it was Mr. Castro who did it because of this scenario. So then Detective Lopez goes to interview the next person that he interviews is a person named Mr. Ortega, who was, according to Mr. Castro, Mr. Ortega is the bakery manager. That's Mr. Castro's business. Mr. Castro had said, as I mentioned before, that he was just got back to his house because he had been at his place of business. Mr. Ortega basically confirms that story. He says that Mr. Castro came over at around 7 o'clock. We were talking business, taking care of business, and Mr. Castro left the bakery sometime after 8 o'clock. He's not sure exactly when after 8 o'clock, but sometime after 8 o'clock is his testimony. Detective Lopez drives from the bakery to the Castro house, and he finds that during moderate traffic, driving in a usual fashion, it takes about 20 minutes. So again, a very significant fact. The next thing that Detective Lopez does is now he has compiled a list of stores in the neighborhood that he thinks might be the place where the knife had been purchased. And so he goes around to all these stores, and fortunately for him, fortunately for the facts of the case, he hits pay dirt. He goes to the 7th store and he meets there Dolores Vega, the owner of the pawn shop, and she, in fact, the detective has taken with him a picture of the knife. There's also a picture of the knife in the evidence that you will be examining. He takes with him a picture of the knife, and Dolores Vega says, yes, I sold that knife sometime earlier. So Detective Lopez also has with him a picture of Mr. Golan, the so-called, the person of which Mr. Castro is jealous. He has a picture of Mr. Golan in a so-called photo lineup. Ms. Vega looks at those photos, and she is not able to identify Mr. Golan. She doesn't recognize him. Detective Lopez also has a picture of Juan Castro. He has that in a photo lineup, and when he shows that to Dolores Vega, she recognizes Juan Castro. She said he was wearing sunglasses at the time, but that is the individual who purchased the knife. So obviously that's a critical piece of evidence for the prosecution. So then that basically is the factual setup. So what we're looking at here in terms of the analysis of the facts, there's a list I think in your materials, but so we see quite a few facts and there are obviously some that go both ways. There are things that are just the basic facts of this case. We see the victim's blood is on the defendant. The house is in disarray. It was the defendant that called the police, and he called the police at a particular time. The victim's blood was on the coat of the coat's lining because, as I said, covered the victim with the coat. Let's see, I didn't mention the paramedics, but they were there. The time to get home from the bakery is obviously a very significant fact. The old lady on the one side, heard something at 8:15. She wasn't sure what it was. She also saw Castro get home at 8:30. You'll see that Perez testifies that she didn't really like the victim. Her eyesight isn't that great. The lights are off in the front at the time that he came in. The defendant appeared calm when he came in, but again, she didn't really see him that well. Of course, a really significant fact from the prosecution point of view is the testimony of the young boy next door, in which he testifies that he saw a red car in the alley behind the house at or about the time that would have facilitated Mr. Castro or anybody really doing the murder. And not only was it a red car, but the boy specifically says that he recognizes this particular red car because he likes the car and he knows the color, etc., etc. There's fingerprints of both the victim and the defendant on the back door handle. We have the gravel in the defendant's shoe, which would similar to the gravel in the alley. Then, of course, the towel and the exotic knife. It appears ultimately that the wounds are consistent with having been caused by this particular knife, so it certainly seems plausible that this is going to have been the murder victim. We have we throw this in for the defendant, I think. We have the orange ceramic ashtray with the unknown fingerprint on it, so apparently somebody else was there perhaps at some point, or somehow anyway that fingerprint got on the ashtray. There was flecks of blood in the sink, as I said, consistent with it being washed off. We have the testimony of the co-worker, the baker, indicating that the accused left the bakery after 8 o'clock, which is also consistent with his statement of, first of all, it gives him an alibi for the time earlier when the car might have been in the alley, and second of all, it's consistent with his story of showing up there at 8:30. Then, of course, we have the pawn shop operator who identifies Juan Castro as the purchaser of the knife. Obviously, that's hugely significant. There's some statements that you'll see that Mr. Golan said that Juan Castro made to him. Heavy blow to the skull and 17 stab wounds. So there's a little something here for everybody. It's going to not be necessarily the easiest possible case for my colleague Scott or anybody else who has to prosecute the thing, because as, of course, we all know with respect to criminal cases, the burden of proof is, and as Scott has told us, it's not impossible, but it's high. It's a reasonable doubt. What else could have happened? How is it possible that, how do you reconcile the fact, if it comes into evidence? You're going to have to do something with the baker's testimony that that Mr. Castro didn't leave the bakery until 8:15, and he couldn't have gotten there in time to pull off the murder. You're going to have to deal with the fact that if you're the prosecutor, you're going to have to deal with the fact that there is apparently some third party potentially around. You know, this ashtray is a problem for the prosecution, and this is the type of thing that you have to have. You have to have a theory. Scott, when he was talking about opening statements, managed to avoid the old cliche of an opening statement as a roadmap. I've always, we do try to avoid that, but to me, the real analogy is like a jigsaw puzzle. And if you're going to put together the puzzle, you can't end up at the end of constructing the puzzle, you can't end up with a couple of pieces that say, oh, you know what, I have the whole picture, but just forget about these, they somehow don't fit, and we don't have to worry about those. And those are the kind of things, like for the prosecution, what about that ashtray? You have to put it in your puzzle somewhere. You can't just build your puzzle and at the end of the day come and tell the judge, don't worry about the ashtray, I don't need that for part of the puzzle, because when you just have to really use all the pieces and have some explanation for all the pieces. Similarly with the testimony of the baker, you'll see in the facts, what they're trying to do to some extent is give you the opportunity to cross-examining these people. The baker has his motives for wanting to support the defendant. There's kind of things in there like that. Similarly with the neighbor, who's the older lady who supports the neighbor. She likes him. She doesn't like the other person. She doesn't see that well. There's opportunities to shake these things, but this is what you got to deal with. The neighbor, the baker, reasonable doubt in people's minds. And of course, on the other side, you know, the important pieces of evidence, it seems to me anyway, and you know, you all decide when you look at it tonight, is the fact that the young boy saw what he believed was Mr. Castro's car in the alleyway at the time, at a perfect time to actually have committed the murder. So the theory of the case could have been, one way you might deal with the neighbor is he went in the back, he committed the crime, and then he left. And later on, he came around and drove into the front, and that would be perfectly consistent with him getting there at 8:30. Now, exactly how you're going to work in the baker, you'll see that the timing makes that pretty difficult for that to overlap. But you're going to have to come up with some issue. So the other, of course, really powerful piece of evidence is the pawn shop owner, who says that it was Mr. Castro who purchased the knife. And so those of us who are, or those of us who end up, or to the extent that we're trying to cross-examine her or put together a case for the defense, we're going to have to come up with how are we going to fit that piece of the puzzle in there. Was she mistaken? Was she lying? How do we deal with that fact? Because if the trier of fact, the judge in your case, decides that it's true that he purchased the knife that ends up being the murder weapon, it's going to be a very difficult fact for you to deal with. So, given the facts that we have, what we need to think about from both a defense and prosecution point of view is we need to think about what is the theory and the theme of our case. So what we're going to go now is we're going to talk about what are a theory and a theme. What is the purpose of a theory and a theme? How do you come up with a theory of a theme, and then a theory and a theme, and then we'll talk about giving some examples. So, you know, this is a kind of concept that applies both in a criminal case and in a civil case. When you go into a case, you need to have, what you want to have is you want to have an overarching conception of what the case is about. What's the case about, and why is it plausible that the position that you're presenting is the correct position that accounts for the facts and meets your burden of proof, and also accounts for the facts that aren't good, that are not in your favor. So the theory of the case is defined as a concise factual statement that explains what happened in a case and why. Each side needs to have their own theory of the case, and each of the theories is going to be different. In this case, of course, what happened here, I mean, we'll see exactly some examples, but I mean, it's pretty obvious that the theory of the case for the prosecution is going to be, in a fit of jealous rage, Juan Castro went out, bought this murder weapon, confronted his girlfriend, and killed her. Now, we're going to have to make sure that the timing of this works. When did he buy the knife versus when he confronted her supposed boyfriend? How is it that the timing is going to work out, that he was in these places? Where, how did he come there at 8:30? What was he actually doing at the bakery? What happened? But that's going to be our concise factual statement of what happened in this case. I suppose from the defense point of view, you're going to find that it'll be something like during the course of a burglary, a Juan Castro's life, the light and life of Juan Castro's life was ripped away from him by a stranger who murdered his girlfriend in the course of a burglary. A theme is kind of a phrase, an image or idea that captures the essence of the facts and the emotion of the case. So when you, particularly in a theme, so I guess what I understand here is that it's a little different. Is you're not typically giving the opening statement, but when you give an opening when you have a jury, and you're giving an opening statement, the first thing that you actually do in a jury case is you select the jury, and so right from the start, when you're selecting the jury, your theme is up front and center. You want to deal with the doctrines of both primacy and repetition. The doctrine of primacy says that people tend to remember what they're hearing first. That the doctrine of repetition, of course, says if you got some important points, you have to repeat them. And you want to repeat them in different ways. You don't want to just keep asking and asking and asking. One of the things that those of you or us who have been to a bunch of trials, sometimes you'll find that the lawyer for one side or another will ask the question over and over and over again. And when you have a jury trial, you actually have the opportunity after the trial to go out and talk to the jury and say, what did I do wrong? What did I do right? What did you like? What you didn't like? What you actually will often hear from a jury is the lawyers, hopefully it's not you, but they'll say, your other side seemed to assume we were idiots. They asked the same question a million times. Why didn't they? We understand, we get it. Our time is valuable. We don't want to hear about it a million times. So the point is that repetition is an important point of your case. You have to have your points come out, but you need to approach them in from different angles. So you get it from several different witnesses. You explain why it's important from different angles. When we talk about, sometimes when you talk about direct, there's the theory of looping. Is you start off with an important point, you build on it, and then you get back to it so that it comes up again. You don't just repeat it over and over and over again. But the theme, and even if you're just going to a judge, the theme is going to be the kind of thing, it's going to inform your papers to the judge. You're going to want to use this as the kind of the hook. When you look for a theme, what you're looking for something is that it's kind of punchy, it has an emotional impact, it's easy to remember, and then that theme is going to run through your case. When you're talking about cross-examination, for example, what are you trying to accomplish in cross-examination? My colleague said very, very clearly, and as a sort of a prelude to what I'm saying here too, is what you're trying to do is you're trying to advance your theory of the case, advance your theme of the case, and conversely discredit or weaken the other side's theory and theme of the case. So, as kind of appears from the definitions, the difference between a theory, the theory is a plain factual statement about the case. A theme is a generalized principle drawn from the case. The theme is going to be the thing that's your kind of short, punchy, one or two line things that has some emotional hook. When you're trying to convince a trier of fact, again, maybe this works more for a jury, but it's certainly also true for a judge, and maybe even more for a judge. You have to have two elements to your case. You have to have both the heart and the mind. The judge is, when you're with a judge, you have to appeal to his mind to say, this is why I'm correct. This is why my theory of the case is what happened. This is how you put together all the pieces of the puzzle and why they fit together in this way. But you also have to appeal to his or her heart, and because a judge, what they want to do, and those of us who've been in front of judges, sometimes maybe it's not that easy to believe, but they really want to do the right thing. They want to do what's fair. They want to do what's right. And so what you want to do is you also want to appeal to them that not only am I intellectually right, my puzzle has fit together this way, but it's the right thing to do. It's the right thing to do. This woman's life has been snatched from her by Juan Castro for no reason whatsoever, and you have a hook there, that it's an emotional hook to show that the judge that he or she is doing the right thing, versus, you know, you could be Juan Castro's life in some ways came to an end that day when a burglar broke into his house and killed the love of his life. And not only that, but now he's standing in front of you falsely accused, even though he has an alibi, even though he has this, even though he has that. Judges are going to want to put it together, and they're also going to want to do what's right. Okay, so the purpose, as we've already sort of gone over, is the purpose of the theory is to distill the facts of the case so that they can be clearly understood. That's important both for you and for the trier of fact. For yourself, this has got to inform. You have to have a theory early in the case. I mean, you want to, or at least you need to be thinking about your theory, because you need to be. There's a whole world of facts that you can find, and so when you're going through your fact finding, you don't want to blind yourself and only go down in the wrong direction, but you also have to select out the facts that that you're going to pursue, particularly in civil matters. I would say in the United States, Marcus, for example, as he said, is an in-house counsel at a drug firm named Pfizer. The world for Marcus it can be literally millions of documents, and the question is, what are you looking for in those millions of documents? Your theory of your case is helping you to find what you're looking for, and even and then conversely, in a much simpler situation, like this murder is, relatively concise set of facts. But there's things that you're going to be looking for. For example, right away, Detective Lopez, what did he need to do? He was looking for, obviously he's looking for a murder weapon. And the evidence led him to, he's in the back, and because he has the theory of the case that somebody anyway killed her with a murder weapon, he's looking for the murder weapon, and his inquiries are shaped by what's in his theory. And similarly with the theme, to convey to the judges how you want them to feel about the case. Again, an emotional hook for the judges. An example. Okay, so we actually get to talking about examples in this particular case. The defendant, well, I guess it's not. The defendant shot and killed his wife because he mistakenly believed she was having an affair. Tailored to this case, it's Mr. Castro stabbed his girlfriend because he mistakenly believed that she was having an affair with Mr. Golan. So then your theme becomes, jealousy is a dangerous companion. If you were making an opening statement, you would be talking about, even before that, if you were selecting the jury, you might say, you have to be careful about this, but you know how personal you get a question. Have you ever been in a situation where you've experienced jealousy? Have you had a friend who had a jealous situation? Were they mistaken about it? How did that come about? And you can kind of explore that, and you're starting to plant the seed of what your theme is in even in the jury selection. In the opening statement, you're talking about what the evidence is going to show, and you're going to be planting again the seed of jealousy. During your direct examination, the theme might be jealousy. You're pursuing. You can be talking when you ask Castro questions, when you ask Golan questions. That theme is going to be helping you to understand what you're looking for in the case. Similarly, from again, I guess the defendant's point of view, what, you know, your emotional hook, again, as perhaps I've already alluded to, would be Mr. Castro's, the light of Mr. Castro's life was tragically ripped from him. You know, catastrophe can strike at any moment out of the blue or something like that. So that'd be the kind of thing for you actually to think about yourselves when you're looking over the materials here. Creating and using a theme. What is the single most powerful thought you want the judges to have while listening to the evidence? Again, while you're putting together of the pieces of the puzzle for the judge, what is the way that you want him or her to be thinking about the case? If you can get the judge to be thinking about the case from your point of view, with your emotional hook, then you obviously have quite an advantage about it. And it also, you know, it gives the judge, it just summarizes it so that all of these things can be starting to be put in your particular puzzle. So you want to have a theme that the judge has clearly in mind, so that he or she knows where you're going and the reason that you're going there. This isn't a journey that you're just taking off and hopefully you're going to end up somewhere. You got to know where you're going, and you got to know how you're going to get there. So somebody has already before used the word preparation. That's the key in any trial. You go to trial, you're prepared. One of my colleagues has said, I think with respect to cross-examination, you have to know all the facts, and you have to have your way that you're crafted to go through the facts. And the only way to do that is to be prepared. You need to be the person in the courtroom that knows the most about the case, because one of the things that you're also going to find in trial is the one thing that you can be absolutely sure about in trial, and I'm going to go out on a limb here, is that everything is not going to happen the way that you expect. You're going to find unexpected things are going to come up. A witness is going to say something that he or she you didn't think they were going to say. They don't say something that you were counting on them going to say. You can't just stop. You got to keep going, and the way that you're going to go and deal with these unexpected things is you know everything about the case. And so then you're able to, if your plan was to go this way, you need to get over there, okay, I got to go around here. You don't stop, you keep going, and the reason that you're able to keep going is because you know everything about the case. And so what you want in order to do this is when you have your theme, you're taking the judge along with you. So some of the things to think about in a theme, you want to make sure that it isn't used against you. Actually, I have a colleague that's just about to go to trial right after I get back, and we talked about the theme of his case. And it turns out to be, I mean, it's a real complicated lease case, but he told me he was thinking about making the theme of the case Mr. Williams continually tried to take advantage of the state, right? Because it ended up being a lease, and it was really a bad lease for the state. So Mr. Williams tried to take advantage of the state, but he's not going to get away with it. And so what I told him is, one of the things that you got to look out for is try to make sure the theme cannot be used against you by the defense. And so I said to my colleague, well, what if they come and say he tried to take advantage of the state and he got away with it? You know, I mean, my colleague wanted the facts that they were going to use is that Mr. Williams continually called us up, and he was badgering us, and he was badgering the appraiser, and he was doing all these things that in retrospect maybe looked like they were kind of overbearing and unfair. And I said, well, you know, maybe that theme will work for you and maybe it won't, but you got to make sure that they don't turn around and say, look, this case isn't about whether Mr. Williams is a bad guy, whether he's overbearing or not. That's irrelevant. The question is, did he do it? If he called up the state all the time and asked them to make it a favorable lease, is that why it's a favorable lease? Yeah, you know, because the state folded. Maybe Mr. Williams wasn't the nicest guy, but that's the deal. And I said, Dan, you got to really be worried about that. Don't let them turn it around and use it against you. So that's one of the things that you think about with the theme. Again, for your opening, start with the theme, repetition and primacy. Start with the theme and continue to restate the theme after you relate the facts. The theme has got to be it's got to be part of the trier of fact psyche. They know where you're coming from. That's your emotional hook. Again, use it not only in the opening statement, but also in the closing argument. Reinforce the theme during the case, not by necessarily repeating it, but by the way that you ask your direct examination questions. Why are you asking cross-examination? You're asking cross-examination to advance your theme, and your question should be advancing your theme or defeating the other side's theme. And if you're not doing that, then don't ask a question on cross-examination. So here's some more examples of themes. In a rape case, the victim lived a nightmare, end the nightmare for her by doing justice. Child abuse. To be given the affection of a child is a sacred privilege. The defendant violated that sacred privilege. Same thing, child molestation. Let no evil befall a child. Protect this child from evil. Some of these might be a little more histrionic than you could actually get away with, but that's the kind of thing that you need to, that's the kind of thing that you need to do. The facts of this case, Your Honor, cry out for justice. To be given the affection of a child is a sacred privilege. The defendant violated that sacred privilege, and it's time for justice to be done. Accomplice, he helps the guilty, shares the crime. The defendant shares the crime. Domestic violence. The law protects both the willing and unwilling equally. Now that's actually a pretty good hook. I like that one. Where intent, acts demonstrate the intention, credibility, personal, yeah, I don't know if I don't see that personal attacks are the tool of those without truth. That's, to me, I'm not sure I would see that as a theme necessarily. That's kind of like a sub-theme, potentially. All right, well anyway, so I want to just say again, thank you very much for the opportunity to have spoken to you today. You guys will all have these materials as well and the opportunity to look at them. I'll look forward to working with you tomorrow.
Another round of applause for Mr. Winhoff. Thank you so much for setting the pace for our practical exercise tomorrow morning. Indeed, it's going to be a wonderful time. It is very important that you have opportunity of reading the practical, the case study tonight. Please, there are a lot of papers there, and you read and you make your own, so that when your class is discussing, because we don't want just the classes, some people to be dominating the conversation. We are all expected to contribute to the discussion going on, because it may be the person, it may be the counsel for the defense or the prosecutor, because we can call anybody to be that, and really this is just a course. It's not like every other course you have attended where you just give lectures. We want it to be hands-on. So by tomorrow morning when you get here, we're going to have the list pasted outside there, and the venue for the different groups where you will meet and discuss and come up with your strategy for the case. And indeed, we are going to stay here and we're going to have the mood, and so that you present your evidence. All you have learned today, you're going to put it in practice tomorrow. So this is your chance at it. So read well, so that tomorrow it will be easy for us to participate fully. Thank you very much. And tomorrow we'll be starting at 9 o'clock. And if you don't have the material, if you don't have the course folder, please go to the registration desk after today, so that you can have your own material, so that you'll be able to read, because you may decide to wait for the online version and you're not able to use that. But please, if you don't have it, please meet them. The students, I'm referring mostly to the students. If you don't have it, please meet them so that you can collect one. So tomorrow we are starting at 9. It's now time for us to go for lunch, and before we all leave, I will invite our speakers to please go out now for your lunch. Please, we are going to have, yes, we're going to have, sir, please, you may join them, please. least we can go for our lunch. Our lunch is now, after our lunch is actually closing, we are done for the day, so that we can come back early. So you see, everything was factored in well, so that you are not caught by the traffic, because we understand the Lagos traffic, so that at least if you can take your lunch, you can hit the road before the traffic catches up with you. Thank you so much. You have been wonderful.